My name's Miranda Hellman, an attorney with the Kentucky Innocence Project. We are a grant-funded group working on wrongful conviction cases and more specifically forensics and DNA cases. For the Kentucky Innocence Project to take a case, typically an incarcerated person or an individual connected with them will contact us, tell us what their basic claims of innocence are, and we will begin an investigation of those claims. So for us to take a case, it would need to meet some minimum criteria and then for there to be some type of claim of innocence that we can investigate.
What prompted you to look into Quincy's case?
Sure. So Quincy actually had contacted the Kentucky Innocence Project probably about 10 years ago. We were funded differently and we were staffed differently back then. So we had some grant funding that had ran out, and as the grant funding slowly ran out, we were losing staffing kind of monthly for a little while. So Quincy's case was picked up from a different staff. They investigated the case. They hit some roadblocks with getting documents, and that's really the first thing we have to move forward. So they weren't able to get quite a bit of documents. They weren't able to locate evidence. They weren't able to get a lot of information from the police that we would need to move forward. And then as funding ended, they just kind of put the case on hold. So we got new grant funding, it's all federally funded, and had some new positions from our state agency. So once we got some new staffing in, we went back to pick up cases that kind of got put on hold or dropped back within that time period where staffing had weaned out. And Quincy's was one that almost immediately jumped at us because there were memos saying that they believed that the investigation should continue, that we needed additional staffing to work on the case, and really laid out some of the claims in Quincy's case well. So we picked it back up maybe mid-2020.
What was your first impression upon meeting him and or speaking with Quincy Cross?
Sure. So Quincy's case was really interesting. It's almost overwhelming. And talking with Quincy, at first he was a little reserved, and I think that part of that was that he's never had great representation throughout the case. I think that he felt that trial could have went differently and his appeal could have went differently. And then with DPA and the Innocence Project specifically, because he hadn't gotten that representation continued and it took so long for us to get back to it, it was difficult to start that relationship again. But he introduced us to his family, co-defendants in the case, made sure we had contact information for everyone, and it was interesting to hear his story and then hear everyone else's story that all matched. All of the timelines, the set of events, everything he talked about, and everyone else, that would talk to us in the case. It was there were no inconsistencies. So that's kind of step one of moving the case forward is, hey, where do we have inconsistencies? Where do we have problems? And it was interesting that Quincy's case really didn't have those things on his side of the case.
So what's your professional opinion, not only on Quincy's conviction, but Jeffrey, Tamara, Victoria, and Venetia?
So with Quincy's case, obviously we accepted the case. We've entered an appearance on his federal habeas action. We believe that there is enough here that we can move forward with his claim of innocence. When we look at cases, some of our minimum criteria, I glossed over that, but some of them are that you are still incarcerated, that you are still serving time on the offense at which you're seeking exoneration of. So unfortunately, we couldn't really look at Jeffrey and Tamara's case or Victoria and Venetia because they weren't still incarcerated. So I think that they had actually maybe applied to the Innocence Project previously, but because just unfortunately that's our bare minimum set of rules. Some of that is because of funding. Some of that is because of the caseloads that we get. So we weren't able to look into their claims, but the claims are so intertwined and their stories are so intertwined and their lives are so intertwined at this point that it's hard, we can't say we're just ignoring Tamara and Jeffrey and Victoria and Venetia because they're so important to the case that we're looking at.
What would you have to say to people that Quincy's been in prison, going on 15 or so years, and if he was innocent, he would have been released by now. What do you have to say to people that, doubt wrongful convictions after they've been in prison for so long?
Innocence work is not quick. It's a long road, even for some of the simpler cases we've seen. Sometimes there's just one issue in an innocence case. Here, we have many issues, and we have been met with roadblocks at every turn. So, the typical innocence case, I know there's a statistic, I should be able to shoot it out, but it's something like at least 7 or 8 years to be able to move towards exoneration. And this isn't any type of case. So in Quincy's case, obviously, we're talking about a capital murder case, one that was investigated for that many years, before they actually had tried someone for the crime. So it's just a very long road to overturn a wrongful conviction. While it is easy to seek a conviction at times with weak and circumstantial evidence, we can't undo that with that same weak and circumstantial evidence. We have to have direct evidence, many times forensic evidence, to be able to overturn those convictions.
What is your professional opinion on the evidence that was used to secure convictions in this case?
In reviewing this trial, I've probably, in the time that I've done post-conviction work in Kentucky, reviewed 15 or 20 murder cases, many of which were tried as capital cases. The evidence in this evidence is in what the prosecution put on in their case was much weaker than what I had seen in other cases. There is no direct evidence that tied Quincy to this crime, to even the crime scene or the story that was told at trial. There are huge inconsistencies in those stories. So when I see, the evidence against Quincy really were a handful of witnesses that said he was there, many of which got a ton of preferential treatment in their own convictions and their own pleas, in other convictions and pleas that they may have been looking at, as well as huge payouts, from the state police for witness protection. So when I look at it, there is no direct evidence. There is no physical evidence. It's just statements of, someone who had a connection to the crime or had, some reason to say what the prosecutors and police wanted them to say.
Feeding off of that, can you speak about the physical evidence that was collected at the crime scene and didn't make it into evidence at the police station?
Sure. So there are different documents throughout the file where we can tell there was a massive amount of evidence at that crime scene. And by crime scene, we can talk about a couple different scenes, I think. So most of the evidence that was collected was the middle school. Lots of evidence was taken from her apartment with really no connection to the crime at all. There was really no indication that this started at her apartment, ended at her apartment, or had anything to do with it. And then there was really no evidence taken from the house at Chris Drive. And there was evidence taken from Jeffrey Burton's house, but years after the crime occurred. And so nothing really comes up helpful to the case for either the prosecution or the defense. A lot of it is what I would call a red herring. It just doesn't matter. So where, we can collect 100 hairs from an apartment, but if that apartment had no connection to this crime, it's just 100 hairs from an apartment, that have nothing to do with it. So when we look at the crime scene of the middle school and, the what was on her body, what was on her clothing itself, hairs or any forensics that would have been on the clothing, even the evidence they collected wasn't processed correctly. So what we do have just really wasn't utilized correctly, and then what we don't have, like the clothing, for example, that they searched really hard to find, and there's no explanation about where it went or why it ended up there, is troubling. So when you are going after a capital murder case and you had evidence about that crime, maybe it wouldn't have told us anything. Maybe the fire or any chemicals that were used would have destroyed the evidence, but there was really no chance either for the prosecution to use it or the police to use it in an investigation and prosecution, or for the person that's been accused of the crime to use it, as some kind of exculpatory evidence to say, no, someone else was here, not these 5 people that you've tried for this crime, but someone else was there, and that person either did it or has information about it, even if it's just a key witness, really could have changed the outcome of any forensic case, and especially in this one where, all of it's gone.
Can you speak about each DNA or each piece of DNA evidence that did go missing and the protocol and procedures when it comes to securing a crime scene? You know, is it typical to let civilians in, 24 plus, you know, officers around a small area where a body is just found?
So I am not an expert in securing the crime scene. I can kind of go off of what I've seen out of SOPs from different police agencies and KSP specifically, that, you know, the scene is supposed to be secured. You are supposed to have control logs of who comes in and out. Anyone can really come in and out, but you are supposed to track who those people are. And part of that is about, you know, say we find some hairs near the body and we test them and we think they have value, but they were actually from the CSU tech that came in and collected evidence. So there's a reason why we keep control logs, and there's a reason why we photograph and write down every piece of information about how evidence is collected. So in this case, so far, not saying it doesn't exist, but I, as part of Quincy's trial attorney file or police file from KSP, have not seen a control log. I have not seen the photos of each piece of evidence that would have been tagged and collected. We have a set of KSP 41 forms, but because KSP came into this case after the crime occurred, while some were there that day that her body was discovered, most of the KSP investigation didn't occur until 2 years later. So we have KSP 41 forms and logs, but they don't necessarily correspond to the day the crime happened. So we don't know whatever existed. We do know that some hairs were there. We've seen them in the logs, things like the hair found on Jessica's shoe, that we don't know if they're in evidence or not. The defense never used them at trial. There were never any testing requests related to those, you know, those hairs. And then we don't know if they're sitting there now. We don't know if they may be at KSP, and no one knows, you know, that's that specific hair, because those control logs and evidence logs and photos don't exist.
Can you speak about the testimony in court? And can you also mention Rosie Price and her being convicted of perjury and even, you know, kicking the prosecutor's table when she walks by?
Sure. So Rosie made some statements, you know, pre-trial, and then was a big piece of not only Quincy's trial, but was also a big piece of Austin Leach's trial. So, you know, we talk about the 6 individuals we talked about, but there's also Austin Leach. So Austin was tried with crimes connected to this murder as well. And in Quincy's trial, Rosie testifies and then comes back, you know, days later and says, actually, that wasn't truthful. It was covered in the media. You know, the press really caught on to it. I think that the defense thinks that's the key to the case. You know, we couldn't get Victoria or Venetia to recant on the stand, but here's Rosie saying, no, that wasn't true. You know, I did this because, you know, I was being paid to do it, because I was told to do it, because I was scared. But at the end of the day, you know, it didn't make a difference at Quincy's trial. While I do think it was key in Austin's trial, you know, that's different charges and a different jury. So it just turned out, you know, it turned out differently for Austin than it did for Quincy. But she had a lot of information. You know, she made a lot of statements. There was a lot of key information in the case that Rosie had access to. And for her to say, actually, none of that was true, I was just doing what someone told me to do, is really, really interesting from, you know, trial prep strategy. But unfortunately, because the jury heard it at trial, we can't, it's just not a claim in post-conviction. It's not new evidence. So it becomes very difficult for us to use Rosie's statements because the jury did hear that, hey, I said something that wasn't truthful. But I've seen the trial tapes. It is clear that she had some animosity when she walked off the stand. I think she felt attacked by both sides and was upset when she left. You know, Quincy has an ongoing innocence case. You know, I know there's been some media coverage, and there have been people on and off throughout the years in Mayfield make a lot of statements about the case. You know, ultimately, Quincy has a really tough road ahead of him. Post-conviction law has a very high standard. It's very hard to undo a conviction or even get a second review of a conviction. Quincy kind of got the short end of the stick in having good attorneys and good investigators work on this case and then be able to put it all together. So unfortunately, you know, the Innocence Project kind of dropped the case for a couple of years, and that cost him some time. He had to do many of his post-conviction filings himself, so that becomes really difficult for someone in prison with no resources and no law degree to be able to write your own briefs and get them up and get good review of those issues. Quincy did file 3 motions himself, all of which were denied. He never had a substantive hearing on the issues, so no judge yet has heard any real evidence on the recantations, the new evidence, cell phone records that weren't entered at trial. All of these pieces of evidence, like the hairs from the wig that they went to great lengths to test and then never actually got any results from, the missing evidence, the diary evidence. Those are all things that we have the means now with new science to look at. And so hopefully, with a motion put in front of the right judge at the right time, we're able to actually get a judge to take notice of the case and take a second look at, here's the evidence sitting in front of you. You get to make a decision now if you think he should get a hearing, even, not even a new trial or an exoneration, but just give him a chance to put this in front of you and you take the testimony and weigh it and see, should he get another chance at this.